Sorry, you hold on for me briefly. Bobby, so if we ignored all the inaccuracies and falsehoods in the statements by both sides, and again, I need to qualify when I say it may be false on the part of the presidency that there are two injunction applications, because once the one was dismissed in July, it doesn't mean that the person cannot file another one. So potentially, the person could have filed another injunction application. So it may be the case that there are two injunction applications. Forget about all of that and come to the position. Was the president right? The law you teach your students. Yes, the book you have written, I have read it. Again this morning before I came.
I'm saying good morning to Senior Penkind and Godwin. Yesterday, somebody called me and said Samson may be a prophet, as if he knew injunctions would be a huge issue. Dedicated several weeks to discuss injunctions.
Those discussions on the law, myself with you and my friend Jemfi in Kumasi, I have played them over and again to listen to you guys again. Yeah.
I think that devoid of all the emotions.
Information before this one.
I'm coming. Yeah.
Emphatic you made. A correction has been sent to me.
What's that?
The Attorney General says that, as to let you know, that there's a fresh application for injunction by Amanda.
Okay.
There are actually two.
Thank you. So that helps it. So there are actually two injunctions.
Okay.
When was the fresh injunction filed?
Yeah, I think I haven't gone through, but he stated it.
Okay.
You're not curious.
Okay. All right, let's go.
He is sending this.
Let's go. No. Relax.
No, but it's for correction.
Let's not be preemptive.
Make an emphatic statement.
Let's not be preemptive.
There are no two applications.
We should believe the Attorney General. We should believe the Attorney General.
We'll deal with that.
Eduji, in the absence of other facts, we should believe the Attorney General when he stakes his neck to say that there is an injunction, another injunction by Amanda. Thank you. Yes, let's go.
Okay. Something I would want to lay the basis of my understanding on this whole process, and it stems from the concluding part of your interaction with them. A suit is commenced generally by the filing of a writ of summons. In the Supreme Court, we just merely refer to it as a writ. Then it comes with your statement of case in the Supreme Court. So I'll just simply say a writ of summons. Now, when you file your writ of summons, you can decide to include in your writ any relief that you want. Now, in your writ of summons, it has been held by the Supreme Court that you cannot include in your writ of summons an interlocutory relief. So a writ of summons cannot be endorsed with a relief of interlocutory injunction, because then the action itself could be dismissed for disclosing no cause of action. There's a Supreme Court decision on that. Now, you can endorse in your writ of summons a relief of perpetual injunction. Now, perpetual injunction is the final injunction that the court may award after the end of the case. Now, it is also trite that the fact that you've endorsed your writ with a relief of perpetual injunction does not in itself operate as an injunction. And so if beyond the perpetual injunction, you desire an interlocutory injunction, you don't include that in your writ. And I have seen that in some of the writs that have been filed. A relief for interlocutory injunction and then a relief for perpetual injunction. The Supreme Court says that interlocutory injunction does not disclose the cause of action. So you cannot put that in your writ. So what you can put in your writ is a perpetual injunction. Now, if beyond the perpetual injunction, pending the final determination of the matter, you seek some status quo to remain, or a reversal, so status quo ante or status quo present to remain, nothing stops you from filing an application for interlocutory injunction. When the application for interlocutory injunction is filed, it must be served on the party that you think wants to take the step that you are seeking to restrain.
Can you pause there and help me with the education, my viewers? Status quo ante and status quo present. What does that mean?
Status quo ante means something has been done, you want it to be reversed pending the determination of the matter. So, for instance, you are litigating over somebody with a land. You were in possession. The person has brought bulldozers there. You can file an application for injunction, and you can include or describe it as you want the status quo ante. It means that the status before the writ was filed. And so if there was no bulldozers on the land, you are asking the court to order the person who has brought the bulldozers to take them back. So that before, what the status was before the writ was filed is what you are asking the court to have it maintained. Now the status quo,
the case itself has been determined, and then we get to know who is the winner. Okay.
If the case is determined and the court says who owns the land, then the court will perpetually restrain the loser and all those who claim title through him from interfering with your possession of the land.
Then the other one.
The status quo present is, as at today, that we are going to court and filing my application. The status is that there are bulldozers on the land. The court should...
Or there is a building...
There's a building on the land. The court should order that nobody should take out the bulldozers, but nobody should come and add new bulldozers. So what it is at the time we file the application for injunction or the writ is what I want to be maintained until the final determination of the matter.
All right.
So those are the various forms of the interlocutory injunction that could be presented to the court. Now, if an interlocutory injunction is filed, whether to maintain status quo ante or the status quo present, once it is served on the parties that we are seeking to restrain them, then those parties cannot take any step which will undermine the authority of the court. Godwin referred to the Benjamin Dufour case, and he also referred to the Alote case, the one we say the Moffat. So that is without dispute. Now, in these facts that we have, I would want to deal with Mr. Sky's suit because I have read the writ and then the injunction application. On the 7th of March, he filed the writ with a statement of case and then said that the whole process that the Parliament went through breached certain provisions of the Constitution. Now, because of that, Parliament should be restrained from submitting the bill to the presidency. As Godwin explained, that once Parliament passes the bill, it goes to the presidency. Presidency assents, it comes back to Parliament, co-minini. Now, beyond filing the writ, on the 8th of March, Richard Sky went ahead to file for an interlocutory relief, asking that pending the determination of the writ, Parliament should be restrained from presenting, pursuant to Article 106, I think, presenting that bill to the presidency.
I understand Amanda Odoi also filed the fresh interlocutory injunction application on the 8th of March.
Interesting. To use Godwin's words, curious.
Yeah. Go ahead.
But I have not read that,
All right.
so I'll deal with the Sky's own. Now, once that interlocutory application, and Parliament has not denied that they've been served with it. They have not denied.
That is so.
Yes. So, to all intents and purposes, Parliament has been served. Now, the Attorney General, that is the principal legal advisor to the government, per Article 88, has also been served. Has also been served with that interlocutory application.
Because he's
not
also
the
a party.
He's also a party. Now, if you are aware that there is a pending interlocutory application to restrain a party from bringing you something, and that party brings it to you, and you receive it in the Alote case, you have opened yourself up to contempt. So you may not have been the person that the interlocutory application was directed to. But if you take a step that will aid that person to undermine the purpose of the interlocutory application, you have also aided. And you would also be liable for the contempt. It was clear in the Alote ex parte Alote case. Now the presidency, my understanding from that letter, is saying that I am aware. So if I receive it, I've also opened myself up to contempt. If I was the president, I would not receive it and say, take me for contempt. I will not. I'll say, don't bring it. We may have our different opinion as to the manner and the choice of words used in the letter.
That's a different thing.
That's a different discussion. And I think that the communication from the presidency to the Parliament, because of the level of authority they all have, could have been done in a better way.
It showed disdain.
It's too strong because disdain would have to mean there's an intention.
Okay.
I'm not in his mind yet, so I will not know whether that was the intention. But I think the communication, a phone call, a discussion at their level. Remember, the Speaker of Parliament was in Parliament with the President, and they are both senior lawyers at the bar, so they would have had some form of relationship. And I don't think that they don't talk or they've never spoken before. So there could have been some other means of having discussions. But that is another, purely on the side of law.
Yes, I
do not think.
I was asking you at this point, is it your view that the performance of the constitutional function of the executive or the legislature can be injuncted?
So that's a general discussion.
Correct.
Okay. Now, if you look at the ex parte NLA case, which was reported Supreme Court, I think 2009, that Teban was very categorical. You cannot use injunction to prevent the performance of a statutory responsibility. That Teban was very, very categorical. You cannot by means of an injunction. Because you see, injunction is an equitable relief. And it will only be granted if there is no other alternative. It is very clear. That is why they ask you when you file for injunctions, would the damage or would the wrong that you are seeking to prevent, can it be compensated by damages? Or is there any other relief? So for instance, if Article 2 says that any step taken by any person in breach of the Constitution can be struck out by the Constitution as being a nullity, if you seek to prevent that step from being taken, that is your right in a substantive action. But if you bring an interlocutory application, the Supreme Court may, and we are having a general discussion without prejudice to the case pending, the Supreme Court may ask itself.
I know why he's posting the caveat.
Yes, because I don't want to. The Supreme Court may ask itself whether there are alternative remedies. That is key because injunction is an equitable remedy.
What if the person seeking the injunction against the performance of the statutory obligation can show that there is a breach of law or procedure in the process?
I have no doubt that you must first establish you have a legal right.
Yes.
You must establish there's a prima facie case. You must establish the balance of convenience. And you must also...
It is not as of right.
Yes, of course. And also that there is no other alternative remedy. There was a case where, I think it's Abu Ramadan, one of the Electoral Commission cases.
Correct.
Where the Supreme Court said that if we grant this injunction, it will lead to a meltdown. So let's go to the substantive because the fact
that's Ransford France.
Ransford France.
When the application for injunction came, this is what my Lord Justice Ansah said. Quote,
in that case?
Yes.
Okay.
The conclusion I come to is that injunctions may not be used to interfere with the processes of Parliament. And as regards to its proceedings within its own war, Parliament is completely privileged from judicial intervention. Completely. And I'm saying that the transmission mechanism is a parliamentary responsibility.
Okay, thank you. So conclude on what you're saying.
Yes, so
I ask you the next leg of that question because the point you made, the general point, is confirmed in the Law of Injunctions, the 11th edition, LexisNexis, and I was reading it. Okay. So, but there is the qualified situation where the officer exercising that statutory obligation or constitutional obligation, so to speak, if there is proof of a breach or violation of law or procedure, then they may be stopped.
But that is what I was going to say, that if, we are still dealing with interlocutory injunction, if this alleged breach of statute is the basis of your substantive application, then the court should not. And you can look at ex parte Mobile.
Okay.
They said, I think 2005, 2006, Georgina Wood, he said, if what you are asking us to determine by this interlocutory process would result in us making conclusions that will affect
resolving the
substantive matter, we will not. So if you say that there has been a breach, and that is why you are seeking substantive relief, the Supreme Court will not entertain an interlocutory application.
Okay.
That would delve into the substantive relief.
All right.
I think
do you think, does it
privilege Parliament?
Does it matter?
You see,
So we all come to, you all come to the conclusion that the tone of the letter somewhat But before he says cease and desist, he says, you are kindly requested. Does it matter how it was preceded?
Like I have said, I'm not, as for the lawfulness of what he sought to.
Not about lawfulness. Not about lawfulness.
If you speak to the content.
Does it sound disrespectful? Does it sound contemptuous of Parliament? If you don't take away, you are kindly requested to cease and desist.
Like I have said, I'm not in a position to determine whether it is contempt or disdain. That is based on the intention of the person who wrote it and the interpretation of the person who received it. All that I'm saying is that perhaps the president at that level could have called the speaker prior to the letter coming, I think. It would have softened the grounds for the receipt of the letter.
Now let's talk about the speaker's action.
Administrative action.
Now let's talk about the speaker's action.
Yes. Now, that is also very curious. Again, in all the submission by Godwin and Senior Penka, they have not seemed to diverge on what the position of the law is.
Correct.
They have not. They all agree that this is the position of the law. It's the interpretation and the application.
Yet Eduji, curiously, like Afenyo Marking, appears to say, if this person does it, it's okay. If this other person does it, it's not okay. But I'm asking you the question now, from the speaker, on the facts that you have come to know, was the speaker right in what he did?
Okay, so on the 20th of March,
Wednesday,
when the speaker said that I have before me a process, he was referring to only a writ.
Correct.
Only a writ. Now, the writ that was filed had in it, I think Zonita Toda filed it, and a relief for interlocutory injunction.
Interesting bit.
And then also a relief for perpetual injunction.
Hold on. Yeah. Go on. I'm talking to Penka, not you.
A relief for interlocutory injunction, also a relief for perpetual injunction. And like I have submitted, I do not think that it is proper to include an interlocutory relief.
That's for a judicial determination.
Yes, let me finish.
So we can be categorical on the law to the extent we know it as settled. And that's why the law teacher is here. Please allow him. I hear a lot of the debate in the public where even media moderators will say, "Oh, if you put 10 lawyers, they will all disagree," which is a lie. Okay, there is settled law that we must educate our populace to know that this is settled law, and not say because Eduji says it's this way, this one says it's this way. There is no settled position. There's a settled position. So please go on.
So you cannot include an interlocutory relief in a writ.
Right.
Now, as at the 20th of March,
right,
when the speaker said that he has before him a motion or an interlocutory injunction, we all know that there was no such application pending. And so if on the 20th of March, the speaker says that based on an interlocutory process or a process before the court, I'm suspending parliamentary proceedings. With all due respect, I do not think he had any legal basis to say that on the 20th of March. If he had said that on the 21st of March...
So he was peddling falsehood.
Maybe. You see, like when you say that, it means there's an intention. Perhaps...
No, but he said he has an injunction motion. He was playing
which we all know it is not.
Because there had not been an injunction motion.
Obvious untruth.
So it was not so. Now, if he had made that statement on the 21st and said, because there is an injunction application, I will suspend and let Supreme Court decide, I would have agreed with him. But on the 20th, there was no such thing. And
why will you agree with him?
Because
when the suit is challenging a category of ministers who are not the subject, who are not the subject of the vetting.
Yes. Again, Samson, the reason why I am slow to go into that is that then you are going into the merits or the
We are not going into the merits.
Because
let's be plain, we are not going into the merits. Let's not hide around it. We are not going into the merit. There are two categories of ministers. Ones whose appointments were revoked and reassigned. We know It's a question of nomenclature. But that nomenclature revoke can bring trouble. That's why we leave that to the Supreme Court to determine whether once you have said revoked, we should treat it as de minimis, that it doesn't really matter. It's only form over substance. Or that, in fact, on the basis of J.H. Mensah versus the Attorney General, once you have said revoked, you must bring them for prior approval.
Yes.
These class of appointments have not been submitted to Parliament for approval.
And what
Then the Speaker says, because of this injunctive process, we also want to respect the courts.
when at that time, the people that were
as of
before,
now, even as of now.
the people that were
that
before
have
them
been
were not
vetted.
the subject matter of the Supreme Court suit.
Exactly.
Then that becomes a different discussion. Because then if at the time that the Speaker was saying that the people that were the subject matter of the Supreme Court action were not the parliamentary proceedings, then did he have a basis to say he's suspending it? But I was listening to Mr. Markin, and there was something interesting that came out. I have heard, because I've not been a member of Parliament before, that in most of the time, before a speaker makes such decisions, he discusses it with the leaders of the different sides before he comes out. Perhaps, and Mr. Markin is saying that did not happen in this instance. That was curious for me as well. Because perhaps if those consultations were made, his attention would have been drawn. But you see, members of the minority, and I've heard Mr. Haruna speak to it, seems to agree with that position. So is it that there's a fundamental misconception of the people that were the subject matter of the suit, or like Mr. Tenka keeps saying, it was pure mischief, just to derail the process?
All right. Very, very interesting.